"Ma'am, you need to stop. This entrance is restricted, authorized personnel only." She looked at his hand, which was still on her shoulder. She looked at his face. She looked at the door behind her, the main entrance to the Harris County Civil Courthouse, a public building, with a sign above the door that read entrance in letters large enough to read from the sidewalk. "This is the public entrance," she said. "It's restricted right now. There's a security situation. You need to go around to the side entrance on Franklin Street." She looked at the door again. Through the glass she could see the security checkpoint, the metal detector, the X-ray belt, the deputy manning the station. People were walking through it. She could see them. A man in a suit, a woman with a briefcase, a young couple holding hands. People were entering the building through this door right now, while the officer's hand was on her shoulder telling her she couldn't. "People are walking through that entrance right now," she said. "Those are authorized personnel. They're civilians. I can see them. They're walking through the metal detector the same way I would." "Ma'am, I'm not going to argue with you. The entrance is restricted. Go around to Franklin." His hand was still on her shoulder. She'd noted that. She'd noted the duration, 11 seconds now by her internal count. She'd noted the pressure, firm, not crushing, but sustained. The kind of grip that communicates control without technically causing injury. The kind of grip that lives in the gray zone between lawful authority and excessive force, where most police complaints go to die. "Remove your hand from my shoulder," she said. She said it the way she said everything, without volume, without threat, without the kind of heat that gives a person an excuse to escalate. She said it the way you'd read a sentence from a legal document, because that's essentially what she was doing. She was issuing an instruction, and the instruction was clear, and the instruction was correct, and the officer's compliance or noncompliance with it was going to determine everything that happened next. Kessler didn't remove his hand. "Ma'am, I need you to turn around and walk to the Franklin Street entrance. If you refuse, I'm going to have to detain you for failure to comply with a lawful order." Directing me away from a public entrance while allowing other civilians to enter is not a lawful order. It's selective enforcement. And your hand has been on my shoulder for 14 seconds. I've asked you to remove it. If you don't, you're committing a battery. She said battery the way a doctor says fracture. Clinical, precise. The numbing of a thing that is happening, not an accusation, not a threat, but a diagnosis. Kessler's grip tightened. Not a lot, just enough. The unconscious response of a man whose authority has been challenged by someone who shouldn't be challenging it, someone who, by his calculation, didn't have the standing or the knowledge or the power to use the word battery and mean it. His calculation was wrong. But he didn't know that yet. Her name was Nadine Okafor. She was 53 years old. She was 5'5". She wore a navy blazer, dark slacks, a cream blouse, and low-heeled shoes that she'd owned for 6 years because they were comfortable, and because she didn't buy clothes to impress courthouses. She didn't buy clothes to impress anyone. She carried a leather messenger bag, scuffed, heavy, the kind that develops a permanent lean from being loaded with the same weight in the same position every day. The bag contained 3 file folders, a laptop, a legal pad, 2 pens, her reading glasses, her phone, her wallet, her keys, and a granola bar she'd packed that morning because she knew from experience that the courthouse vending machines were unreliable and she didn't skip meals anymore. Not at 53. Not with the blood pressure. She had no badge, no lanyard, no credential visible on her person. She looked like what she'd looked like every morning for the past 26 years, a black woman walking into a courthouse to work. The work she did, we'll get to that. What mattered right now, on these steps, was what she could see that no one else was seeing. She could see that Kessler's body camera was off. The small LED indicator on his chest unit was dark. She knew what an active body camera looked like: green light, steady, and this one was dark. Either it had been turned off, or it hadn't been turned on at the start of his shift. Either way, The camera that was supposed to document every public interaction this officer had was not documenting this one. She could see that Vega's camera was also off. She could see that the security checkpoint inside the building was operating normally. No heightened alert, no additional screening, no indication of any security situation that would justify restricting a public entrance. The deputy at the metal detector was leaning against his station, scrolling his phone. That wasn't the posture of a building on alert. There was no security situation. Kessler had fabricated it. The way you fabricate a reason when the real reason, the 1-second calculation, the scan, the sorting, can't be spoken out loud. She could see the lawyer in the charcoal suit, who had lowered his phone and was now watching with the kind of attention that professionals pay when they recognize a professional situation deteriorating. His eyes were moving between Kessler's hand and Nadine's face, performing his own assessment. And she could see the court clerk with the lanyard and the folders, who had stopped at the top of the steps and was looking at Nadine, not at Kessler, at Nadine, with an expression of recognition. Not recognition of Nadine's face, recognition of the situation. The clerk was a black woman, mid-30s, and her expression said, "I know what this is. I've seen it before. I've been it before." Nadine saw all of this in the space of 4 seconds. She processed it the way she processed everything, rapidly, thoroughly, with the particular cognitive architecture of a person who had spent 26 years evaluating evidence and reaching conclusions under pressure. "Officer Kessler," she said, "I'm going to tell you 3 things and then I'm going to walk through that door." Kessler's jaw tightened. "Ma'am." "First, your body camera is off. So is your partner's. Whatever happens in the next 60 seconds will not be recorded by your equipment, but it will be recorded by the security camera above that door." She pointed without looking, which is operated by the Harris County Facilities Division and which captures the full width of these steps in continuous loop. She watched his eyes flick upward. He saw the camera, a small dome-shaped unit mounted above the entrance. The red indicator light was on. "Second, there is no security situation at this entrance. The checkpoint inside is operating at normal status. Your deputy is on his phone. You fabricated a restriction to prevent me from entering a public building while allowing other civilians to enter freely. That's not law enforcement. That's obstruction." She paused, not for effect, for precision. She wanted the next sentence to arrive with its full weight, and weight required space. "Third, my name is Nadine Okafor. I'm the presiding judge of the 270th District Court of Harris County, Texas. My courtroom is on the 6th floor of this building. I've entered through this door every working day for 11 years, and your hand is still on my shoulder." The silence on those steps was absolute. Not quiet, absolute. The silence of 8 people and 2 officers and a set of limestone steps holding their breath at the same time. The silence of a word, "judge," landing on a moment and cracking it open like a stone dropped onto ice. Kessler's hand came off her shoulder. It didn't release slowly. It snapped back, the reflexive retraction of a man who has just realized that the surface he was gripping was electrified. Vega, behind him, took a full step backward. Nadine didn't move. She stood on the step exactly where she'd been standing when Kessler grabbed her. She didn't advance. She didn't retreat. She let the silence do its work, because silence after a truth like that is more effective than any sentence. Then she adjusted her blazer where the fabric had been pulled. She bent down, picked up her empty coffee cup from the step, and placed it in the trash receptacle beside the door. She straightened. She looked at Kessler. He was pale. The confidence was gone. The jaw was no longer tight, it was slack, the jaw of a man whose internal architecture had just collapsed. "I'll be filing a formal complaint with the Sheriff's Office Internal Affairs Division this afternoon," she said. "I'll be requesting the security camera footage from facilities, and I'll be requesting your body camera activation logs for today, which will show whether your cameras were deliberately deactivated or were never turned on. Either answer is a policy violation." She said it without anger, without satisfaction, without the faintest trace of the triumph that someone else might have felt in this moment. The "do you know who I am" victory, the power reversal, the payoff. She didn't feel triumph. She felt tired. The specific, bone-deep tiredness of a woman who had been walking into courthouses for 26 years and who, at 53, was still being grabbed on the steps. She walked past Kessler. She walked past Vega. She opened the door. She walked through the security checkpoint. The deputy at the metal detector straightened up when he saw her, recognition immediate, and she took the elevator to the 6th floor and she walked into her chambers and she set her bag on her desk and she sat down in her chair. She looked at her shoulder. The fabric of the blazer was stretched where Kessler had gripped it, a small distortion in the weave, barely visible, the kind of thing a dry cleaner might fix or might not. She opened her laptop. She began drafting the complaint. She wrote the time, the location, the officers' names, the badge numbers she'd memorized, the duration of contact, the fabricated security restriction, the deactivated cameras, the witnesses on the steps. She wrote it the way she wrote judicial opinions, with precision, with citation, with the unadorned authority of facts arranged in the order they occurred. The complaint moved through the system, the way complaints from district judges move through systems, with speed and seriousness that complaints from ordinary citizens almost never receive. And Nadine knew that. She knew that the response she was about to get was not the response that the average black woman grabbed on courthouse steps would get, and the disparity between the two responses was itself an injustice. A structural injustice baked into the system she served and tried every day to make more fair. But she filed it anyway, because the filing wasn't just for her. It was for the record, and the record was for the next woman, the woman without the title, without the chambers, without the judicial authority that made internal affairs sit up straight. The security footage was pulled within hours. It showed everything. Kessler approaching Nadine from behind, the grab, the coffee spilling, the 14 seconds of sustained contact, the other civilians walking through the entrance unimpeded, all of it clear, time-stamped, unarguable. The body camera logs were pulled. Both cameras had been manually deactivated at 7:48 a.m., 12 minutes before Kessler's shift at the courthouse entrance began. Manually, not a malfunction, a choice. The internal affairs investigation took 4 weeks. Kessler was found to have violated 4 departmental policies: unauthorized use of force, deactivation of body-worn camera, false statement to a member of the public regarding facility status, and failure to identify a legitimate basis for a stop. Vega was found to have violated 2, camera deactivation and failure to intervene. Kessler was suspended for 30 days without pay and placed on a 12-month performance plan that included mandatory retraining in use of force protocols, public contact standards, and bias awareness education. Vega received a written reprimand and was required to complete the same training. But Nadine didn't stop there. She requested a meeting with the Harris County Sheriff, not as a complainant, as a judge. She sat across from Sheriff Raymond Garza in his office and placed the security footage on the table between them. "This happened on the steps of my courthouse," she said. "I want to know how often it happens when the person being grabbed isn't a judge." Sheriff Garza didn't have an answer because nobody was counting. Nadine asked him to start counting. She proposed a quarterly audit of courthouse security interactions, documented through body camera footage, facility cameras, and civilian complaints, with demographic data collected and reviewed by an independent oversight panel. She proposed that the panel include 2 community members, a civil rights attorney, and a judicial representative. Garza agreed, not enthusiastically, not because he wanted to, because a district judge had asked, and a district judge's ask carried the weight of a building with her name on the docket. The panel was established within 60 days. Its first quarterly report found that courthouse security stops at public entrances were 3.4 times more likely to involve Black and Latino civilians than white civilians, after controlling for time of day, entrance location, and security alert status. The report also found that body cameras were deactivated during 14% of public contact incidents, a rate that the panel described as incompatible with accountability. The sheriff's office implemented mandatory camera activation protocols tied to shift check-in. Officers who deactivated their cameras during public contact without documented justification were subject to automatic disciplinary review. Within 6 months, the deactivation rate dropped to 2%. And the stops, the disproportionate stops, those changed too, slowly. Not because the officer's internal calculations changed overnight. Those calculations were deep and they were old and they ran on fuel that no training module could drain in a single session. But because the cameras were on, because the data was being collected, because someone was counting. And when someone is counting, behavior changes, not because the person has become better, but because the person has become visible. Visibility is not virtue, but it's the beginning of accountability. And accountability, sustained over time, can become culture. And culture, if you're patient, if you're as patient as a woman who's been walking into courthouses for 26 years, culture can become change. Nadine Okafor still enters through the main door of the Harris County Civil Courthouse every morning. She still wears the navy blazer, though she had it repaired. The weave was fixable. She still carries the scuffed messenger bag. She still packs a granola bar. She still notices things. The cameras above the door. The officers at the steps. The people walking in, the civilians, the lawyers, the clerks, the defendants, the families of defendants. The people who come to court not because they want to, but because the system has summoned them, and who deserve to walk through the front door without being grabbed. She watches. She notices who gets stopped and who doesn't. She notices when a camera light is dark. She notices the 14-second grip, the fabricated restriction, the 1-second calculation that runs on something older than policy and deeper than training. She notices all of it, and she writes it down, not always in a formal complaint, sometimes in the small notebook she keeps in her bag, sometimes in the margin of a legal pad, sometimes just in her memory, filed and cataloged with the same precision she brings to every judicial opinion she writes. The record exists because she keeps it, and she keeps it because Dorothy Okafor, her mother, a woman who cleaned office buildings in 3rd Ward for 31 years, told her something when she was 9 years old that she's never forgotten. Her mother said, "When they put their hands on you, you remember. You remember the time, the place, and the name. Because one day you'll be in a room where remembering matters. And when that day comes, you won't need to shout. You'll just need to be right." Nadine was right on those courthouse steps. She's been right her whole life. And every morning, she walks through the front door. Not the side entrance, not the Franklin Street bypass, not the route that someone else decided was appropriate for a woman who looked like her. The front door. Every morning. Because it was always hers.